So with that, I'm going to hand it over to our presenter, Maripat Pileggi. She's from Community Legal Services.
Okay, great. Sorry. So I am going to try my best, like Brianna said, to answer your questions as you enter them in the chat box, and then hopefully save some time at the end to also answer questions. But if I don't get to your question today, or if we leave today and you think of a new question, please feel free to reach out to me. This is my contact information here on the first slide. Email is probably the best way to reach me, so please feel free to use that email address if you have questions. I'm going to get started because we have a lot to cover today. My slides are not advancing. Here we go. So this is what we are going to try to cover today. So we're going to talk a little bit about how to figure out what your client's immigration status is. And then we're going to talk about, once you figure out what that status is, what that means in terms of what types of public benefits they might be able to get. We're going to go through the biggies today. So medical assistance, SNAP, formerly called food stamps, cash assistance, and SSI. Then we are going to talk about some of the major benefits access issues that immigrants tend to face. So even if folks are indeed eligible for a public benefit program, they might still have some issues when trying to access those public benefits, or might not be able to access them at all because of issues like sponsor deeming, and or public charge. And of course, there are lots of other access barriers that immigrants face when trying to access public benefits. I can't discuss them all today, so I'm just going to focus today on these two major current barriers that folks are facing: sponsor deeming and public charge. And then, as I said, we're going to do our best to leave time for your questions. So we're going to start off just by going through some more of the common immigration statuses that we see at CLS and that you might see in your programs among your clients. Starting with refugees. Refugees are people who leave their home countries because of fear for their lives or for the safety of themselves or their family, fear of persecution in their home country that their government will not or cannot protect them from. And they enter the US with that refugee status in place already. So as soon as they arrive here, they are refugees. Asylum seekers are folks who arrive here without that refugee status in place yet. So these are folks who also are fleeing their home countries because of fear for their lives or for the safety of themselves or their family, persecution that their government cannot or will not protect them from, serious human rights abuses. But they don't, they get here and then they ask for that refugee status once they arrive. So these are folks who are asylum seekers. They apply for asylum here in the US. And if they are granted that status, then they become asylees at that time. Lawful permanent residents are non-citizens who have been granted authorization to live and work here in the US on a permanent basis. People become eligible for this status through a number of different ways. They can become eligible for this status through a family relationship or through an employment relationship. But then also many humanitarian immigrants like refugees and asylees can also become lawful permanent residents as well. People with this status have what we call a green card. It's not green anymore, but we still call it a green card. And that's the card that they use to prove that they are lawful permanent residents. Undocumented is a term that we use to talk about people who either entered the US without inspection or who entered with a lawful status that has now expired and they have not adjusted to any new status. So for example, if someone came here on a visitor's visa and that visa was good for 6 months and it has now expired and they have not taken any other action to get any other status here in the US, that person will be undocumented now that the visa is expired. Cuban entrant is a pretty specific term in federal law. It's not just anybody from Cuba, but it it's a lot of the people from Cuba who are now here in the US. Cuban citizens who present themselves at the US border and have been paroled into the US or have applied for asylum here in the US. And it is still true that once a Cuban entrant, kind of always a Cuban entrant. So even if someone was paroled into the US and that parole has now expired and that person has been ordered deported, since we're not deporting people back to Cuba, as long as they're here, they remain a Cuban entrant. And that's really important because Cuban entrants have pretty much just exactly as much access to public benefits as US citizens. So it's important to identify a Cuban entrant when you can. VAWA self-petitioners. VAWA is the Violence Against Women Act, which has been around for a long time, and it does many things. One of the things it does is it says that if you are married to a US citizen or a lawful permanent resident and you are eligible to become a lawful permanent resident through that spousal relationship, you don't have to stick around in that spousal relationship if your spouse becomes abusive. Just to get the lawful permanent resident status that you are otherwise eligible to receive. So you can separate from your abusive spouse and petition to get your green card on your own, separate from your abusive spouse. As soon as you petition the government to ask them to permit you to get your green card on your own, separate from your abusive spouse, at that point you become a VAWA self-petitioner. Even before the green card application has been submitted. U visas are available to victims of certain crimes in the US. Usually they are violent crimes here in the US. Oftentimes people who have U visas now were undocumented at the time of the crime. And folks can get these U visas if they're cooperating with investigation and prosecution of the crime. And folks who get U visas are on a path to a green card. So I think after 2 or 3 years with a U visa, you can adjust to become a lawful permanent resident. Special immigrant juveniles is a status that's available to some of the unaccompanied minors coming up from Central America, as an example, and for children who have been abused, abandoned, or neglected. Temporary protected status is a status that's available to people who are from countries that have been designated as dangerous. So every once in a while, the Department of Homeland Security will designate some country as too dangerous to deport people back to, usually after some event, natural disaster. For example, Haiti, after the earthquake, got a TPS, a temporary protected status designation. So folks who were here in the US at the time of that earthquake could get this temporary protected status to protect them from deportation back to Haiti. And those folks, as an example, those folks from Haiti can still get TPS status. And there are some people who have been in the US with temporary protected status for decades. But that does not come with a path to a green card. So those folks are they just have TPS. And unless they develop some other eligibility for lawful permanent residency, they might only ever have TPS here in the US. DACA, I think folks are generally familiar with this term, otherwise known as the Dreamers, as this is the Deferred Action for Childhood Arrivals program available to people who arrived here in the US as children. DACA also has no green card path like TPS, so until some legislative action to change that for the Dreamers, the most that group of people have in terms of an immigration status path or option is DACA, deferred action. All right, so that's just a handful, right? So these are just some examples I wanted to put out there as terms that people might be familiar with from your work with immigrant clients. But there are many, many other ways that people can be here in the US, many different statuses that they might have. And it is not always easy to figure out which status your client has. You might find that if you just ask what is your immigration status, some people won't know what kind of information you're actually asking for. They won't know how to answer the question. They might not understand the term, or it might be that just having that question asked kind of as the first question out of your mouth might scare people, right? So it's a good idea to take a couple steps back, kind of explain to people why you need to know about their immigration status. If you're a legal advocate, explain that this information that you're telling them that you're asking for, you have to keep confidential. Give people some context. But then it's also a good idea to take a couple steps back to really try to actually figure out what your client status is, because some people don't know. But even if they understand what you're asking and why you're asking, they might not know what their status is. The immigration process is very long, it's very confusing. There are many winding paths that some people go down in their immigration case. So you often have to start kind of from the beginning. Say, well, when did you come to the US and how did you get here? Like, was it on an airplane, or was it by foot, or was it by boat, right? Just really get to the basics, right? Did you have a document that you needed to show to get into the US? What was that document? Do you still have the document? Can I take a look at it? Did somebody apply for you to come to the US before you got here? Or have you applied for something since you got here? And do you have documentation about what that application process is or was? And then, of course, do you have an immigration lawyer, right? So if you really can't figure it out with somebody, maybe the person that's helping your client with their immigration case can help you figure it out. What you really don't ever want to do, and nobody should ever do, is send your client off to the local USCIS, the local immigration office, to ask there, right? Too risky. Don't do that. If you really are stuck, and the person does not have an immigration lawyer, we have immigration lawyers in the legal services world right here in Pennsylvania that we can talk to for a consult, or perhaps to connect your client to for some immigration legal help. Of course, documents always help if folks have them. This is just some of the documents that folks might have, and I have some examples here in the slides that follow. This is one of the more recent iterations of the green card, the lawful permanent resident card. They change the format every few years. I actually think it doesn't quite look like this anymore. It looks a little different. And I should get the most recent one up here in this slide, but this is basically what the lawful permanent resident card looks like. And I circled here some key pieces of information on the card that you want to pay attention to when you're trying to help a client get public benefits. So the USCIS number is also known as the alien registration number, or the A number. It's all the same number. Folks will need that number when filling out the application for benefits like medical assistance or SNAP or cash assistance. So it's right there if folks are looking for it. The category next to the USCIS number tells you what made this person eligible for the green card in the first place. How did they enter the US? It tells you a little bit about their underlying immigration status. So for example, this RE8 code, category code, means that this person is a refugee. And that's very important to know, right? As we will discuss later on, refugees have access to many, many public benefits. And they have access, in some cases, they have access to more public benefits than other people with green cards. So it's very important to know that this person is not just a green card holder, but also a refugee. And then the resident since date tells you when this person became a lawful permanent resident. And that becomes useful for people who are subject to what we call the 5-year bar, which we will discuss later. So there are some people who have green cards who have to wait 5 years with the green card before they will become eligible for certain public benefits. So for those folks, it's really important to know when that lawful permanent resident status started, so you know how much longer they have in that 5-year waiting period, if any time left in that 5-year waiting period. So that's the green card. This is an employment authorization card. People with green cards won't have one of these because the green card itself is their employment authorization card. But for folks without green cards, you know, there are lots of folks who don't yet have green cards, but who are authorized to work here in the US. And so those folks might have one of these cards. It has that same USCIS number on it. And then it has a category code. And just to keep things interesting, they use a different set of category codes for the employment authorization card than they do for the lawful permanent resident card. So you have a different set of codes to look up if you have a client with an employment authorization card. So this C09 category code, I'm pretty sure means somebody who has a pending application for a green card, right? So they have an immigrant visa that allows them to be here and work here in the US, and they're in the process of getting a green card, but they don't have it yet. And that is going to be a really important piece of information when you are trying to figure out what kind of public benefits this person might be able to get. This is a naturalization certificate, also has that USCIS number on it, which, if I'm understanding correctly, if folks are applying for Obamacare on the marketplace, naturalized US citizens often need to still, even though they're US citizens, they still need to put this USCIS number, their A number, into that application in order to verify that they're a citizen. So it's a useful piece of information to have, and it's right there on the naturalization certificate if folks have that handy. These are I-94s. These are the records of entry and into the US and departure from the US for non-citizens. On the right is a paper I-94, and on the left is an electronic I-94. As I understand it, they stopped issuing paper I-94s several years ago. So people who entered recently might not have one of these, but if you are working with somebody who's been here for a while, they might still have one of these paper I-94s. Sometimes you'll see them stapled into people's passports. And so people will get this, you know, stamped kind of on their way into the US, and you'll see some information here about when they were admitted into the US and why they were admitted. So this class of admission, this B1, shows you that this person was, you know, entered on a temporary visa that has, in both of these cases, for both of these people, it looks like their admission into the US has now expired, right? So if, for either of these folks, if they're still here in the US and they have not done anything else in their immigration case, there is no visa extension or any new immigration status that they've obtained since these visas expired, then they both now are undocumented. But these kinds of documents help you to figure that out. These are some websites that you can use to help you figure out what your client's status is. The USCIS case status online, you can go on, your client can go on there to find out what's going on with their immigration case, you know, kind of what the next step is if they've applied for some kind of immigration status. The Customs and Border Patrol website you can go to look at those electronic I-94s that we just looked at in the last slide. And then those category codes on the green cards and on the employment authorization cards are available online for you to look up. So you can take a look and see what those category codes on your client's cards mean. All right. So once you have a good idea about what your client's status is, then what you can do, the next step in this process when trying to figure out what benefits they might be able to get, is to figure out which of these big buckets, these big categories of immigration statuses they might fit into. So, you know, the public benefits law is quite a maze of both federal statute and federal regulation and state statute and state regulation, and kind of mushing all of that together and sorting it all out, what you will find is that public benefits laws create these four big categories of immigration statuses. So they take all this gigantic world of immigration law and all of the different ways that people can be here and the different statuses they might have, and they squish them into these four boxes, right? So our next kind of step in this process is to figuring out which one of these four categories your client's immigration status, what puts them in, which box we can put your client into. This is a visual representation of how these four categories fit together. Lawfully present is the biggest bubble, the biggest box, the biggest category, and it includes the most immigration statuses. PRUCAL, which stands for permanently residing under color of law, is almost entirely a subset of lawfully present, but not entirely. You'll see there's a little sliver off to the right there of folks that are PRUCAL but are not lawfully present, and we'll talk about who they are and why we care about that sliver in a minute. The qualified folks, this term qualified immigrant comes from the 1996 welfare reform law, the federal welfare reform law. And that federal law has this kind of exclusive list of people who are, quote, qualified. So these are the lucky few who made it through that terrible welfare reform process back in 1996. So that the people on that exclusive list are the people that the federal government decided back in 1996 are worthy of federal benefits, in terms of what their immigration status is. Humanitarian immigrants are entirely a subset of qualified, and kind of the darker your shade of blue, the deeper down into this hole you get, the less likely you are to have an immigration status problem when you're trying to access public benefits. And then, of course, unfortunately, our undocumented folks are, for the most part, stuck out in their own little bubble without any access to public benefits, with one or two exceptions, which we will talk about later on. So a little bit more about who are in each of these categories. Lawfully present, like I said, is the broadest of these categories. It includes pretty much everybody who's here for any amount of time with permission. And it includes even people who are here for very short periods of time, like tourists. People with tourist visas are lawfully present. Also people with U visas, we talked about U visas, they are lawfully present. People with temporary protected status, which we talked about, they are lawfully present. People with pending asylum applications, children with pending asylum applications, when those asylum applications have been pending for at least 180 days, are lawfully present. And that's very important because there are lots of folks here who are applying for asylum and are stuck in a years-long waiting process, waiting for a final decision on their asylum applications. Many of those people are lawfully present while they are waiting for those asylum applications to be adjudicated, which gives them some access to public benefits, which we'll talk about in a minute. People with pending applications for green cards are lawfully present, and then pretty much everybody with employment authorization is lawfully present. So going back to asylum applicants, an adult with an asylum application can apply for work authorization once the asylum application has been pending for 150 days. So if folks are waiting on an asylum application and they are work authorized while they're waiting, they are lawfully present. So it includes a lot of people. Lawfully present includes deferred action. So there are lots and lots of ways for people to get deferred action. But somebody who happened to get deferred action through the Deferred Action for Childhood Arrivals program, or DACA, are not lawfully present for the purposes of federal health benefits eligibility. So this is a pretty terrible policy decision that the Obama administration actually made. After they created DACA, they then created this special exception for people with DACA that would exclude them from the definition of lawful presence just for the purposes of federal health benefits eligibility. So people with DACA are lawfully present in all other respects, right? They are allowed to be here. They are protected from deportation. They are allowed to work. They're allowed to join our militaries. You know, they're allowed to do it all. But there's this terrible exclusion of them from the definition of lawful presence for the purposes of federal health benefits eligibility, unfortunately. Qualified immigrants, remember they are entirely a subset of lawfully present. So if you're qualified, you are also lawfully present. And this is the exclusive list of people who made it through that 1996 Welfare Reform Act. And so if you're not on this exclusive list, that 1996 law said that you are ineligible for federal benefits. So the people on this list are lawful permanent residents, ballot petitioners, people who have been paroled into the US for at least 1 year, and then humanitarian immigrants, which includes refugees, asylees, Cuban Haitian entrants, trafficking victims, which are people who have T visas, and then people with withholding of deportation or withholding of removal. And that's it. So I have not mentioned withholding of deportation or withholding of removal yet. The test for that status is very similar to the test for refugees and asylees. The main difference is that people with withholding of deportation don't have a green card path, right? So people with refugee status, people with asylum status can get a green card. People with withholding of deportation cannot. But they are humanitarian. They are just like asylees here and allowed to stay here because of fear of violence in their home countries or persecution. And that brings us to PRUCAL, these permanently residing under color of law folks. This also is a very broad status, and it includes everybody who's here for a long-term or a more permanent basis with permission from federal immigration officials. This term is only relevant for state benefits purposes. It is not relevant for federal benefits purposes. And so I mention it here because we do have some state benefits here in Pennsylvania, some benefits that are entirely funded with state money. And so this term PRUCAL is relevant for those state benefits programs. And because PRUCAL is defined so broadly, and because there is no exception in the definition of PRUCAL for DACA, people with DACA, and all people with deferred action, but including people with DACA, are PRUCAL. And so even though people with DACA can't get federal health benefits, they might be able to get state health benefits. So that's really important to keep in mind for them. And then there are these other kind of smaller groups of people who are not lawfully present, but who are potentially PRUCAL. And so even though they can't get federal benefits because they're not lawfully present, they might be able to get some state benefits. So this includes people with pending asylum applications who are adults who don't yet have work authorization, right? So those folks, once they get the work authorization, they're lawfully present, but before they get work authorization, they are not lawfully present. So these kind of smaller groups of folks who are here with permission, but who are not yet lawfully present, I'm gonna keep this PRUCAL in mind for them if they, and think about whether they might be able to get state benefits. And we'll talk more in a minute about what they All right. So, and now, of course, everyone else pretty much just includes our undocumented people. Those are the only people who are left out of those other categories of lawfully present, PRU-Call, and qualified. All right, so there's that visual representation again, now with that little sliver of PRU-Call, people who are PRU-Call but not lawfully present labeled for you. All right. So now we know our client status. We've figured out which of those big categories to fit them in, either lawfully present, PRU-Call, qualified, humanitarian. Now we can start to connect that status to the public benefits that they might be eligible for. I'm going to start with medical assistance, which is by far the most complicated of, in terms of immigrant eligibility. It is by far the most complicated of all the public benefits programs we'll talk about today.
Yeah, this is Brianna. Excuse me. I think before we launch into the MA, we should maybe launch our first poll. So for study purposes, I'm going to send a poll to confirm everyone's participation. The poll is going to be active for 2 minutes. Please be sure to complete if you are taking this for CLE credit. If you do not complete it, we're not going to be able to issue the credits for your time in this session. So I'm going to launch this now and it'll stay live for 2 minutes. Thanks. I'm going to hand it back over to you, Maripat.
Okay. All right. And a reminder to folks that if you have questions, please put them in the chat box. I actually can't see the chat box, but Brianna's going to be is going to be keeping an eye on it for me. All right. So, medical assistance. The reason it's the most complicated of the benefits programs we're going to discuss today is because we have these two medical assistance programs in the state. We have a federal medical assistance program and we have a state medical assistance program, and the rules about which immigrants are eligible for each changes. So there are different immigrant eligibility rules for each of these programs. I'm going to do a very brief overview of what the federal MA programs are, and then talk about which immigrants are eligible for those programs, and then do a very brief overview of what our state MA programs are, and then talk about which immigrants are eligible for those. Starting with federal MA, these are our big, major federal MA programs that most people enrolled in federal MA will find themselves in. Starting with Healthy Horizons. Healthy Horizons is available to people over age 65 or people who are disabled at least 12 months. There's a 100% of the federal poverty line income limit and an asset limit of $2,000 or $3,000. MAUD is the Medical Assistance for Workers with Disabilities program. It is available to people who are disabled, working, and under age 65. The income limit is 250% of the federal poverty line, and there's a $10,000 asset limit. Because it's available to people with slightly higher incomes, people have to buy into it. It is not free like every other medical assistance program. People have to pay 5% of their monthly income for MAUD. MAGI MA, MAGI stands for Modified Adjusted Gross Income, and they call these categories of medical assistance MAGI MA because the rules about which income counts and who counts as members of the medical assistance household are all based on tax rules, right? So that's where the Modified Adjusted Gross Income term comes from. So people who might be eligible for one of the MAGI MA programs are pregnant women, children, and people in the expansion adult population, so adults between ages 18 and 65, up to 138% of the federal poverty line. There's no asset test for those groups of folks. So in order to be eligible for any one of those federal MA programs, you must also be either a lawfully present child under age 21 or a lawfully present pregnant adult, or a qualified immigrant who's been in the US with a qualified status for at least 5 years, or a qualified immigrant who's been qualified for less than 5 years, but who is exempt from the 5-year bar. So I mentioned that 5-year bar before. The 1996 Federal Welfare Reform Law created this 5-year waiting period for some qualified people that they must wait out before they become eligible for some federal benefits, including federal medical assistance. Who is exempt from the 5-year bar? Humanitarian immigrants, right? So refugees, asylees, Cuban entrants, people with withholding of deportation, T visa holders. None of those folks need to wait the 5 years. As soon as they get that status, as soon as an asylum, somebody who with a pending asylum application gets their asylum application approved, they now have an immigration status that makes them potentially eligible for federal MA. They don't have to wait 5 years, as an example. Children under age 21 and pregnant adults do not have to wait the 5 years. People who have been continuously present in the US since 1996, they don't have to wait 5 years. We don't see too many of those folks anymore, but every once in a while, one crops up. And then some folks with military history do not have to wait the 5 years. So who are we left with? Who is going to be stuck in this 5-year waiting period? Well, we have people with green cards who got their green card on a family petition. So these are folks whose sons, daughters, husbands, wives petitioned to for that person's green card, and they became eligible for the green card through that spouse or that family relationship. Made them eligible for the green card. People with employment-based petitions for green cards are also subject to the 5-year bar, but for the most part, those folks have jobs that would make them income ineligible for medical assistance. We don't really see those folks. Diversity lottery winners. So there's what they call the diversity immigration lottery, which permits people from countries that are underrepresented here in the US to, after a whole lot of vetting, they can, and they're approved to throw their name into the hat, basically. And the lucky few who get their names pulled from that hat can immigrate here to the US, they get their green cards, but once they get here, they're going to be subject to the 5-year waiting period. And then VAWA petitioners. Unfortunately, folks tend to think that VAWA petitioners are kind of like humanitarian, right? They're humanitarian-ish, and they are, you know, in many ways they are humanitarian-ish. But they are not kind of defined in federal law as these humanitarian immigrants who are exempt from the 5-year bar. They are subject to the 5-year bar. So as soon as somebody gets that permission back from from federal immigration officials to petition for the green card on their own, separate from their abusive spouse, they become a VAWA petitioner and their 5-year bar clock starts ticking. So unless they are under age 21 or they're pregnant, probably they will be ineligible for federal MA because of their immigration status. But it's important for those people stuck in the 5-year bar to remember that we also have these state MA programs. And we have 2 main state MA programs. We have GAMA, which stands for General Assistance Medical Assistance. Some folks might know that General Assistance Cash Assistance was eliminated last year by the state legislature. But it was just the cash assistance portion of general assistance. The medical assistance portion still exists and it's still available. And it is available to all the same people who were eligible for general assistance cash assistance. So people with disabilities, people in drug or alcohol rehab, domestic violence victims. The big problem with this program is the income limits and the asset limits are very, very low. They are the cash assistance grant amounts. So people who were getting general assistance cash assistance were getting $205 a month generally. In Philly, the grant amounts change slightly from county to county. But yeah, so a single person getting GA cash was getting $205 a month. A couple would get $316. And those are the income limits for general assistance, medical assistance. We also have this MNO program, medically needy only, which is available to a little bit more people, a few more people. It's available to people age 59 or older, and then to parents under age 21, parents of children under age 21. The income and asset limits are a little bit higher, but are still pretty low. There's this funky 6-month income calculation, but generally people are around like 40 or 45% of the federal poverty line if they're eligible for this program. So the income limit is still very low, and so it is still very hard for people to be eligible for these programs because the income limits are very low. But it's really important to keep these programs in mind because state MA is available to many, many more immigrants than federal MA is. So there is no 5-year bar for state-funded medical assistance. Qualified immigrants ineligible for federal MA because of the 5-year bar can get state-funded MA. And even if you're not qualified and you're just lawfully present, you can get state-funded MA. So that's the big bubble, right? That's the broadest category. That includes a lot of different immigration statuses potentially eligible for this program. And then PRU-QALs, right? The people who are in that little sliver of people who are PRU-QAL but not lawfully present. State law says that they are eligible for state-funded medical assistance. So they should try to get it if they're otherwise eligible. So important to keep that in mind for these immigrants. So who are we left with though? Like who will still, even though we have state-funded MA, who's still going to be left out? Well, undocumented people, right? Undocumented people will always have an immigration status problem to accessing medical assistance. PRU-QALs who are not eligible for state-funded MA, right, because their income is too high or because they're not a parent or they're not disabled or whatever it is that makes them ineligible for state-funded MA, they're going to have an immigration status problem to accessing medical assistance as well. Lawfully present folks who are not pregnant and who are not children and who are ineligible for state-funded MA, and then qualified immigrants who are stuck in the 5-year bar and are not eligible for state-funded MA will also have an immigration status problem to accessing medical assistance. For those two groups though, for the lawfully present and the qualified folks, important to keep in mind that they can go on the marketplace and purchase insurance there with subsidies from the government to help them purchase insurance on the marketplace. And it's especially important to keep that in mind now because open enrollment for the marketplace starts November 1st. So it's just around the corner almost. So now's the time to do it. Open enrollment will be November 1st to January 15th this year. So people should do that if they can. But for all of these folks, their only medical assistance option is emergency medical assistance. So in order to be eligible for emergency medical assistance, you have to be eligible for medical assistance in all respects, except the immigration status eligibility criteria. And the thing that gets you over that immigration status restriction is having an emergency medical condition. So you have to prove that you have an emergency medical condition. An emergency medical condition is not something that puts you in the ER necessarily. It does not mean that you are about to die necessarily. It is a much broader definition than that. It includes many more things, many more services than just services delivered in an emergency room. This is the definition here, copied and pasted right from the law. And you will see, if you look closely, it doesn't say anything about being about to die or being in the emergency room. It is much broader than that. And in Pennsylvania, we are able to get emergency medical assistance authorized to cover cancer treatments, surgical procedures, dialysis, repair of broken bones, high-risk pregnancies, medications, like medications that people just need to go to the pharmacy to pick up every month. Sometimes we were able to get emergency medical assistance for those things, like immunosuppressant medications that people who have received donated organs need to keep their bodies from rejecting their organs, anti-seizure medications, insulin for people who have insulin-dependent diabetes. We are CLS and the Community Justice Project have done a whole lot of advocacy for a number of years to get the State Department of Human Services to interpret that definition of emergency medical condition as broadly as possible. And we've had some success. So we are able to often get emergency medical assistance authorized for things that even are on this list, right? And for services anywhere from, you know, just kind of routine doctor visits to medicines at the pharmacy to like surgery or chemotherapy, you know, something more serious or more involved, I should say. So keep that in mind. EMA might be a possibility if somebody's immigration status is making them ineligible for medical assistance. Pennsylvania is one of a couple handfuls now of states that have explicitly said that COVID-19 testing, diagnosis, or treatment is an emergency medical condition. So if somebody just needs a COVID test, they can get EMA to cover the cost of that. But then also if they have COVID and they need treatment, emergency medical assistance is available to cover that as well. This is a handout I should have mentioned. So in the Sketch app, you know, there are a bunch of, in the page for this session, there are a bunch of handouts there. This is one of them. And the handout itself is a 2-page handout. And on the back, so it's a 1-page handout with 2 sides. And the back, the second page is lists pretty much everything we just went through, like who is pro call, who is qualified, who's subject to the 5-year bar, who's lawfully present. So if you want to print it out and just have it as something you can hold all of that information just in one hand, it can be a handy thing to keep around if you are grappling with these questions on a regular basis about health insurance for immigrants. All right. So that's medical assistance. And we are going to move on now to cash assistance. Real brief overview of the cash assistance programs we have here in Pennsylvania. TANF is available to families with children, and also available to pregnant adults. General assistance, like I said, the general assistance cash assistance program was eliminated last year, but we are fighting real hard to get it back. So don't forget about it.
Hey, Mary
Yeah.
Pat, we had gotten a question. Could a disabled child who is DACA be in GA-related medical assistance?
Yeah, certainly could try, yes. And the policy handbooks that the county assistance offices use to make medical assistance eligibility determinations don't say that PRU-Call folks are eligible, which is wrong, right? Because state law still says that PRU-Calls can get state-funded MA. So I mentioned that because if your DACA child applies for medical assistance, they might be denied. But we should fight to get them approved. So be in touch with me if you want to talk more about that.
Oh, and we had one more question come in the meantime. What would you tell an undocumented individual with an EMC who would be eligible for EMA but are fearful of applying because it's a government program and it might bring up privacy or ICE concerns.
Yeah, I'm going to hold that question because I think I'm going to address it in one of my slides that are coming up. So when I get to the section here on mixed status households and I don't answer your question, please let me know. Okay, so quick overview on cash assistance still. So these are the cash assistance grant amounts. They are very low. They have not changed since 1990. And because the grant amounts are so low, there are very few people who get cash in Pennsylvania, citizen and non-citizen. But for those who need it, it is a very important program. And it is available to qualified folks, regardless of how long they've been here. There is no 5-year bar. And then PRU-calls. PRU-calls have this state law claim. Like I just said, the policy handbooks at the county assistance offices do not mention PRU-call. So the people at the county assistance offices don't know that PRU-calls have this right to state benefits to TANF, to GA, or to GAMA, or to MNO. So we might need to fight for them, but I am happy to have that fight. And if you are thinking about having that fight for a client, please let me know and we can talk more about it. SNAP is, so that's it for cash, right? Real simple compared to medical assistance. Pretty straightforward. SNAP is available to households, so any group of people who are living under one roof and who purchase and prepare food together. There are some exceptions for kids under age 22 who must be included with their parents if they're living with their parents. So even if you have a 20-year-old who's working and buying their own food, they still have to be included with their parents if they're living in their parents' home. And then people over age 60 with disabilities may separate to be their own SNAP households, even if they are purchasing and preparing with other people in their home. There's no asset test for SNAP, and the income limit is relatively high when compared to other programs. It's 160% of the federal poverty line for most people, but then it goes up to 200% of the federal poverty line if someone is elderly or disabled. You got to be qualified to get SNAP. If you are not in that exclusive list of qualified folks, then your immigration status is going to make you ineligible for SNAP. In addition, there is a 5-year bar for SNAP, so you have to have your qualified status for at least 5 years. There are exceptions to the 5-year bar for SNAP, just like there are exceptions to the 5-year bar for federal medical assistance. So there's no 5-year bar for humanitarian immigrants. There is no 5-year bar for children under age 18. And you'll recall that there's a 5-year bar exception for children under 21 for federal MA. So this is a little bit different. It's 21 for medical assistance, 18 for SNAP. There is no 5-year bar for, there's no 5-year bar for folks who are receiving disability-related benefits. And for qualified immigrants who have had their qualified status for less than 5 years, really the only disability-related benefit that they can get is general assistance, medical assistance for a disability. So you'll recall that general assistance, medical assistance is available to people with disabilities if they meet those very low income and asset limits for the general assistance income and asset limits. But if you have somebody who is disabled for at least 12 months and who meets those low GA income and asset limits, and you can verify that their disability will last at least 12 months, it's a twofer, right? You can get them general assistance, medical assistance, and you can get them SNAP. You can get them this exception to the 5-year bar for SNAP. So keep that in mind for your recently arrived qualified immigrant clients. People with green cards who have 40 quarters of work history are not subject to the SNAP 5-year bar, and then folks with military history are also exempt from the SNAP 5-year bar. And that's it for SNAP. A little more complicated, but again, more straightforward, I think, than medical assistance. A little bit easier to understand. SSI has the most restrictive rules about immigrant eligibility of any of the public benefits programs we'll talk about today. SSI, for folks who don't know, is a cash benefit program administered by the Social Security Administration. So this is the only benefit we're going to talk about today that is not administered by the State Department of Human Services. This one comes from the Social Security Office. And it's available to people who have insufficient work history to qualify for Social Security retirement or Social Security disability payments, or they're eligible for a little bit in Social Security retirement or Social Security disability payments, some amount that's less than the full SSI amount. So then they can get a little bit of Social Security and a little bit of SSI together. In addition to that, they also have to be either over age 65 or disabled, and they have to have low income and assets. These are the SSI amounts for 2020, 783 for a single person, 1175 for a couple. The state kicks in a little bit extra, $22.10 for a single person, $33.30 for a couple. And then the resource limits or the asset test is $2,000 for a single person, $3,000 for a couple. So immigrant, like I said, immigrant eligibility rules for SSI are very restrictive. Humanitarian immigrants can get SSI during their first 7 years in the US with a humanitarian status, except Cuban entrants. There's no 7-year limit for them. They can get SSI throughout the entire time that they are a Cuban entrant. But if you are humanitarian in any other way, so if you are a refugee, an asylee, you have withholding of deportation, you have a T visa, you're going to be limited to, your SSI will be limited just to those first 7 years with that status. So for refugees, for example, refugees arrive here in the US with their refugee status already in place. So from day one, from the first day they arrive here, their clock is ticking. Their 7-year clock starts ticking. Folks are expected within those 7 years to adjust to a green card, to get their green card, and then naturalize, become a US citizen. They're supposed to do that within those 7 years, which is very unreasonable for some people to have that expectation, but the expectation is still there. So if folks after 7 years are not US citizens and they're getting SSI, their SSI will be cut off. So it's really important that if you're working with a refugee and asylee, that you are and they're getting SSI, it's very important to be talking with them about their plans to get their green card and to naturalize, to become a US citizen so they don't lose their SSI. Outside of that group, outside of this humanitarian Cuban entrant group, it is very, very, very difficult for anybody who is not a US citizen to get SSI. There are these small little groups of qualified folks who can get SSI. So people who are qualified and who have been lawfully residing in the US since August 22nd, 1996, and who are currently disabled. So if somebody's been lawfully residing since August 22nd, 1996, and now they're over age 65, being over age 65 isn't enough. You have to then also prove that you're disabled. And you have to prove that you've been lawfully residing since August 22nd, 1996. Very tough for people to meet that. People with green cards who entered after August 22nd, 1996 have to have been qualified for 5 years and have 40 quarters. People can cobble together their own work history, their own quarters of work history with a spouse's quarters to try to cobble together 40 quarters of work history. But again, that's very, very difficult. I think I've met like 1 or 2 people who've been able to do that over my last 13 years at CLS. Really hard. And then some folks with military history also can get SSI. So beyond that, you can't get SSI. So for many of my people who are non-citizens who either are getting SSI or who need SSI, what I'm telling them is naturalize, become a US citizen as soon as possible, because otherwise SSI is probably out of your reach. Your status will make you ineligible. All right, that's SSI. I'm going to move on to a couple slides on mixed status families before launching into sponsor gaming and public charge. All right, so there are lots of families out there that are made up of folks with a whole bunch of different statuses, right? Probably the most common scenario that we encounter at CLS is undocumented parents with US citizen children. And I'm going to guess that you all see those families too in your practices. And the important thing to remember is, who are you trying to get public benefits for? That's the person whose immigration status you care about, right? That's going to tell you what public benefits that person can get. The immigration status of their parents and spouses and children is irrelevant. It's just the individual who's applying for benefits whose status matters. And so because it's only the person who's trying to get benefits whose status matters, that's the only person who's going to ever have to provide any information or documentation about their immigration status when they are applying for benefits for themselves. Yep.
Maripat, I'm gonna weigh in with a question that kind of tail ends what you were just talking about, and it goes into what you're about to. This question says, have you seen that applicants within the 5-year bar apply and get approved? This person said that they've had clients who have told them that relatives or friends have applied within the 5 years and gotten approved, and they want to apply too, but what are the consequences if someone is approved for public benefits within the 5-year bar?
Yeah, so I mean, it's a tough thing to figure out sometimes because the options for people who are subject to the 5-year bar are limited, right? They're pretty much limited to state-funded medical assistance, TANF or GA cash assistance, and then SNAP for some people, if they can prove that they're exempt from the 5-year bar for some reason. And then, of course, there are all the exemptions to the federal MA to the 5-year bar. So it really depends. I mean, it's a very kind of individualized question. You got to figure out what how old the person is. Are they pregnant? Are they getting a disability-related benefit? If they're not, are they disabled? Could they get a disability-related benefit? What's their income? To try to figure out if they are potentially eligible for one of the few public benefits that are available to people who are stuck in the 5-year bar. So I have found that the County Assistance Office does not a great job of identifying all of the public benefits that 5-year barred folks might be eligible for. Sometimes they get it right, but sometimes they don't. So it's important to kind of pay attention and make sure that the County Assistance Office is making the right decisions.
They had a follow-up question too on what do you advise someone that has a sponsor and applied for public benefits?
Yeah, I'm going to talk about sponsor deeming a little bit, and hopefully if we can get to the next slide. So I'm going to hold on to that question.
Great. Why don't you go from here and we'll move through that material then.
Awesome. Thank you. When filling out a benefits application, the only people who will need to answer the questions about immigration status or provide any documentation about what their status is are the people who are applying for benefits for themselves, right? So going back to the example of an undocumented parent with US citizen children, if an undocumented parent is applying for medical assistance or for SNAP or for TANF for her US citizen children, she doesn't have to tell the County Assistance Office anything about her status at all. She shouldn't be asked for any information about her status, and she doesn't have to provide any documentation about what her status is or is not. If she's not applying for herself, she doesn't have to give that information. People without social security numbers, just skip over the question about the social security number, leave it blank. So an undocumented mother applying for US citizen children will probably have to do that. She'll have to fill out, enter her name as the children's mother, but then skip over that block where that asks for her social security number. People who are not applying for themselves or who are only applying for emergency medical assistance can also just skip over the questions about immigration status for themselves. Because they're not required to provide any of that information, they don't have to answer those questions, just leave them blank. If somebody's applying for emergency medical assistance for themselves, The only thing they should ever say, and the only thing they should ever be asked to say about what their status is my status makes me eligible for emergency medical assistance only, right? So that way you're not saying I'm illegal, you're not saying I'm undocumented, you're not saying I don't have any status, right? You're just saying the status that I do have only makes me eligible for emergency medical assistance, right? And so that's why I'm only asking for emergency medical assistance. Very important for people to know that there are very robust privacy protections built into the laws that create the medical assistance program and the SNAP program and the TANF program. Especially medical assistance, right? Because there are these kind of HIPAA ideas around medical assistance. Very robust privacy protections, and those privacy protections don't just apply to the people who are applying for the benefits for themselves. It also applies to everybody whose name appears on the application. So if an undocumented mother is applying for medical assistance or SNAP or cash assistance for her US citizen children, the information she enters about herself, her name, her date of birth, her address, that is all as protected by the state as the information about her children, the medical assistance recipients, is protected by the state. ICE, for example, cannot go to the county assistance office and get somebody's address out of the county assistance office. Absent a judicial warrant, there is no way for anybody to get that information from the county assistance office. ICE does not have access to the county assistance office's records. So people are protected through that application process. All right, moving on to the questions about sponsors. This is a huge issue lately. It's always been an issue, it's always been a concern, but it's more of an issue lately, as all things immigrant related are. So starting from the top here, a sponsor is the person who signs an affidavit of support, and the affidavit of support is part of an individual's application for an immigrant visa, and the immigrant visa is a precursor to the green card application, right? So generally, everybody who comes to the US, immigrates to the US, and applies for a green card to live here permanently in the US on a family petition has to have a sponsor. So they have to have an affidavit of support as part of their green card application when they're entering on this family-based petition. There are lots of other people who come to the US who do not have sponsors or need sponsors. So refugees, asylees, special immigrant juveniles, UNT visa holders, none of those folks have or need sponsors. So it's a pretty limited group of people, this group of people who entered the US, immigrated to the US on a family-based petition who have sponsors. In the affidavit of support that the sponsor signs, they promise to maintain support for the sponsored immigrant at or above 125% of the federal poverty line. And then they also promise to reimburse the government for any means-tested public benefits that the sponsored immigrant receives here in the US. So kind of taking from those promises in the affidavit of support, public benefits rules say that when a sponsored immigrant applies for a public benefit, some portion of the sponsor's immigrant is going to be deemed available to the sponsored immigrant when the sponsored immigrant is applying for public benefits. So that's where this term sponsor deeming comes from. And then, from the promise in the affidavit of support to reimburse the government for the benefits the sponsored immigrant receives, the government has this potential claim against the sponsor. If the sponsored immigrant receives public benefits, the government can seek reimbursement from the sponsor for the value of those means-tested benefits. So how does that, and the affidavit of support lives for a long time. Some people think it lives for only 5 years, kind of conflating the 5-year bar rules with the affidavit of support rules. It's more than 5 years. So the affidavit of support is in effect until the sponsored immigrant naturalizes, which could be 5 years, but for a lot of people, it takes longer for them to become a US citizen. Or the sponsored immigrant obtains 40 quarters of work history here in the US, or the sponsored immigrant leaves the country permanently, or the sponsor dies. So it can be a really long time, anywhere from like 5 years or up is how long it lives. The way these rules work in practice, though, is much different and much less scary than the initial affidavit of support kind of makes it sound. So in Pennsylvania, we have sponsor deeming for SNAP, TANF, and GA cash. If we ever get GA cash back, there will be sponsor deeming again for it. So if somebody's applying for food stamps or applying for TANF, the county assistance office will ask that person, if somebody who is sponsored, a sponsored immigrant, applies for SNAP or applies for TANF, the county assistance office will ask that person to verify what their sponsor's income is, and then the county assistance office will count a portion of that income as available to that person when determining that person's eligibility for SNAP or TANF. There is no sponsor deeming for medical assistance or CHIP at all in Pennsylvania. There are lots of exceptions to sponsor deeming. So people who are indigent don't have to deal with any of this. Indigence is defined as somebody whose own income plus any other support they get equals or is less than 130% of the federal poverty line. So people who are indigent don't have to do sponsor deeming. Domestic violence victims, they are exempt from sponsor deeming for generally up to 12 months, but some people can get it extended to longer, especially VAWA petitioners can get it extended longer than 12 months. Children under age 18 are not subject to sponsor deeming for SNAP. And then SNAP recipients who are part of their sponsor's household don't have to deal with sponsor deeming, right? So if somebody is sponsored and their sponsor is their spouse and they're living with their spouse, they don't have to worry about this sponsor deeming stuff. Some sponsored immigrants would rather just, if you're working with somebody who's a sponsored immigrant, they don't want to deal with this at all. And there are a lot of those folks. They don't want to think about the exemptions. They don't want to bother their sponsor. They don't want to take any risk of getting their sponsor in any kind of whiff of trouble. They have the option of just taking themselves off the SNAP grant entirely and just getting SNAP for the other eligible members of their family. And so some people like to take that option. Reimbursement is a really scary thing for people to think about. Like I said, people really, really, really don't want to get their sponsors in trouble, especially if they're members of their family, right? They don't want to put their sons and daughters and husbands and wives at risk of these reimbursement actions by the government. The thing of it is, though, is that these reimbursement actions don't happen. Pennsylvania has never done this. I don't know of any state that does do it. Federal benefit agencies don't do it either. So there's a very good chance that people can, sponsored immigrants can get benefits without risking these reimbursement actions. But people are really afraid, in part because President Trump issued this memo last year that said he really wants to do sponsor deeming and he really wants to go after sponsors for reimbursement. And there has been some movement since then through the Federal Department of Health and Human Services to change sponsor deeming rules, some pressure on states to do sponsor deeming, like pressure here in Pennsylvania to do sponsor deeming in medical assistance and CHIP. But nothing has actually changed. Everything remains the same for now. We are, of course, watching it very closely to see if it does change and to be on top of it if it starts to change. But nothing has changed as of now. So that's sponsor deeming and reimbursement.
This might be a good time, excuse me, this is Brianna. We're going to issue the second poll for the CLE credits. So I'm going to send that to confirm your participation. And like our poll before, it's going to be active for 2 minutes. So please be sure to complete this so that we can credit you for the CLE for your time in this session. Thanks, and I'm gonna hand it back to you, Maripat.
Awesome, thank you so much. So I'm gonna keep going. because we just have a few minutes left and this really important topic to cover before we're done. Public charge is another huge issue for people. It's another thing that has always been on immigrant communities' minds, but never like it is now. So public charge has been around for a very long time. It's been a part of federal law since the 1800s. And it functions in federal law in a couple different ways. One of the things that it does is it creates this public charge grounds of inadmissibility. And what that means is that immigration officials can deny some people's applications for visas or green cards if the immigration official finds that that person is a public charge. So the first thing to note, and what I've highlighted here, is it's just about visa and green card applications, and it's not even about all visa and green card applications. It only applies to some people, this subset of visa and green card applications. So because it's just about visas and visa applications and green card applications, it's not about anything else, right? So public charge cannot be used to deny a US citizenship application, for example, which is a huge misconception out there. I have talked to many people who are applying and applying for US citizenship, and who are afraid that they can be denied because of public charge, and that's just not true. If you are at the point in your immigration case where you're applying for your US citizenship, that application for US citizenship can't be denied on public charge. Green card renewals cannot be denied on public charge grounds. So green cards, once you get the green card, once you become a lawful permanent resident, you get a green card that for most people is good for 10 years. And then after 10 years, you have to go get a new card. And it's kind of like renewing your driver's license. It's not like you have to go in and prove that you still know how to drive. When you renew your driver's license, you just get a new card. And that's kind of what a green card renewal is like too. So you can't be denied a green card renewal on public charge grounds. Asylum applications cannot be denied because of public charge. DACA renewals cannot be denied on public charge grounds. Temporary protected status applications or renewals cannot be denied on public charge grounds. VAWA petitions cannot be denied on public charge grounds. UNT visa applications cannot be denied on public charge grounds, and special immigrant juvenile applications cannot be denied on public charge grounds. So that's a lot of stuff that cannot be denied on public charge grounds. It really is just about initial green card applications and visa applications. And then there are even some people who, when they go to apply for a green card, can't be denied a green card on public charge grounds. So refugees, asylees, VAWA petitioners, special immigrant juveniles, UNT visa holders are all exempt from the public charge grounds of inadmissibility. So when they go ahead and take that next step in their immigration case, which is to get the green card, they can just submit the green card application without any concern about public charge. They can't be denied public charge on or green cards on public charge grounds. So that's a whole lot of people, right, who are just safe from all public charge concerns, because it's not part of their lives. It's not part of their immigration case. It's not a test they're going to have to pass in order to move through to US citizenship. So US citizens are safe. Green card holders are safe. You will see here in that second green box that if green card holders leave the US for 180 days or more, they could potentially have a public charge problem when they try to come back to the US. But as long as they're coming and going in less than those 6 months, they're fine. They can come and go as they please without any public charge concern. And then humanitarian immigrants and crime victims, safe. So UNT visa folks are safe, asylees are safe, refugees are safe, special immigrant juveniles, VAWA self-petitioners. Public charge is not for them, okay? So the people who do need to kind of slow down and think a little bit are the people who are going to apply or are currently in the process of applying for a green card or a visa on a family petition. So these family-based immigrants, again, are the people who are at risk here. And so for them, a public charge determination could mean the denial of their visa or their green card. And notice I have a yellow wait sign here. I don't have a big red stop sign. just because you're subject to public charge does not mean that you should just drop off all your public benefits or not apply for any public benefits. There are lots of public benefits that these folks can still get safely. And we just want to talk for a few minutes about what public benefits they can get. So a little bit of background, public charge has been around for a long time, and for a very long time, since 1999, we had this public charge policy in place that was very restrictive. So the definition of public charge in that 1999 policy was someone who depends almost exclusively on the government for very basic subsistence. So because that definition is so narrow, there were only really two types of public benefits that could be considered during the public charge test under the old policy. So cash assistance, TANF, general assistance, SSI, or long-term care medical assistance for nursing home admissions. And that's it. Any other public benefit could not be considered at all. And then in addition to that, even if you got those benefits, if you had an affidavit of support signed by somebody, that was enforceable, that was enough to get over the public charge test. The affidavit of support was dispositive in almost all cases. It was enough to get you past this public charge test. That all changed in February, this past February. New public charge policies went into effect. And these new policies will remain in effect probably throughout while litigation continues. So there are 10 lawsuits challenging these new public charge rules. And we don't know how those lawsuits will end, but until we know that, we're stuck with these policies being implemented. So what the new public charge policy does is it expands the definition of public charge to mean anybody who is more likely than not to use any of the public benefits listed here on this slide for 12 months or more in any 36-month period. So it's a much broader definition than we had in the 1999 guidance. The public benefits that are implicated are cash assistance, federal medical assistance, so regular old federal medical assistance, with the exception of emergency medical assistance for children, and medical assistance for pregnant adults. Those forms of medical assistance are not implicated under the new public charge rules, so people can safely get those forms of federal medical assistance without any public charge risk. SNAP is implicated in the new rule, and then federal housing subsidies and public housing also in the new public charge policy. So if you received any of those benefits listed on that last slide, then that can be counted against you and when you are applying for your green card or your visa, if you are subject to public charge during that green card and visa application process. But if your family members receive those benefits, that cannot be counted against you. So it's just your own receipt of benefits that's counted. So if you are, a mom who's applying for your green card on a family petition and you have two U.S. citizen children, your U.S. citizen children can get medical assistance, SNAP, TANF, without any risk to you when you go and apply for your green card. The rule will not be retroactively applied. So green card and visa applications submitted before February 24th will be adjudicated under the old 1999 rules, and benefits received before February 24th will not be counted against people after February 24th. So just a couple of main points I want to make. The list of public benefits in the new rule is pretty small, right? And there are many, many more public benefits out there that create no public charge risk for anybody. And so the result of those 2 points is that among the very small group of immigrants who are subject to the public charge test, there are very, very, very few of them who can receive benefits and then have that benefit receipt create a public charge risk for them, right? So like I said, so that list of public benefits that actually create risk under the new rule is pretty short. This is the list right here again: cash assistance, federal medical assistance with the exceptions for medical assistance for children, pregnant people, and people with emergency medical conditions, SNAP, and then federal subsidized housing. Now, we just spent a whole lot of time talking about how difficult it is for immigrants to get those public benefits, right? And for those of you who are doing this work, it might be obvious to you that people who are subject to public charge, people who do not yet have their green cards because they are still in the green card application process, can't get any of those benefits, right? They're ineligible for SNAP because they don't have their green card yet. They're ineligible for federal medical assistance because they don't have their green card yet, right? So there are just very, very few people who are both subject to public charge and who have actual, in fact, access, eligibility for the public benefits that create public charge risk. There are very, very many more, there are very, very many more public benefits available to people who are applying for green cards that create no public charge risk at all. So on this slide, every single benefit on here people can safely receive because it does not create a public charge risk to them at all, ever, right? It's not in the new public charge regulation as a risky benefit. And I know that we are almost at time, and I'm happy that I made it this far through public charge. Are there any other questions in the list there?
We don't have any other questions that were newly asked, but there was a follow-up question to the one about can someone who, sorry about that. Can someone who is here on TPS and had their status expire but worked enough to apply for Social Security retirement, even though this person is now out of status, can this applicant apply for Social Security retirement and not have current legal status?
Unfortunately not. You need you need to be lawfully present in order to get Social Security benefits. I don't think there's an option for that person, unless there's some immigration option, right? Some way to get them lawfully present again so they can start receiving those benefits.
And we just had two more viewers ask questions. One is, can you share the list of people who are subject to public charge and have access to those public benefits?
Yeah.
Can you send that to me and I can upload it to the conference materials?
So I think I just want to make sure I understand the question. So my next slide here is about people with withholding of removal or withholding of deportation. This is really the only group of people. This status is really the only status that both gives people access, makes people eligible, potentially eligible for the public benefits that create public charge risk under the new rule, and who also potentially have a public charge test in their future. So remember I mentioned that people with withholding of removal are not eligible for a green card with just withholding of removal. So people live here their whole lives sometimes with this status and nothing else. Some of those people will develop family relationships while they're living here that will make them eligible for a green card on a family petition. So maybe somebody's here, they get withholding, and then they marry a US citizen. Now they can petition to get their green card through that spousal relationship, and they're going to be subject to the public charge test when they apply for that green card. This is the only group, they have a humanitarian status, so they can get SNAP, they can get federal MA without restriction. But if they find themselves on a green card path through a family petition, they're going to be subject to public charge. They are very unique. This is the only status that I can think of that both they have access to public benefits that create public charge risk, and they potentially are at public charge risk in the future.
Thank you.
Yeah.
If anybody has, we are a little bit over time, so I want to be respectful of everybody's time commitments this afternoon. So I know that we have one or two more questions, but maybe I can just provide those to you outside of the webinar. And if anybody has any questions or thinks of one after this is over, I'm going to put my email right now in the chat. And I will put you in touch with Maripat after this presentation.
Yeah.
This will also be made public if you want to go back and review it, any of the information. So,
yeah. Yeah, and like I said at the top, these slides are available in Sketch, and my email address is right there. So if people want to just email me too, that's fine.
Either one works.
Yep.
Thank you, Maripat, for your time and your contributions this afternoon. And thank you to everybody who attended this session. I hope everyone has a great weekend and enjoys the rest of their day.
Thank you. Bye-bye.